During a medical malpractice trial, especially during a break in your trial, can you approach the bench, can you approach the judge and talk to him about his legal rulings and ask him questions about it? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now imagine this scenario. You brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. The defense refuses to acknowledge they did anything wrong. They say, hey, we did nothing wrong here. You don't like it? We'll see you at trial. And now they refuse to negotiate during the 3 years your case is ongoing. So your case goes all the way to trial. And you and your attorney are putting on testimony and evidence. And during the course of your trial, there are various legal rulings that the judge is making. There are certain objections that are being made by the various attorneys. In some instances, the judge says, listen, I'm not allowing the jury to see that evidence. I'm refusing to allow the jury to see it. I'm not admitting it into evidence. In other instances, an attorney will object to the way a question is asked. And the judge says, objection sustained. Counselor, ask a different question. And now you have questions in your own mind about the various legal rulings that the judge has made. And you would like nothing more than to ask the judge questions about those legal rulings, about why he reached certain decisions that he did during the course of your trial. Can you go up during a break and ask the judge, excuse me, Judge, can I ask you some questions about the various legal rulings that you've made in my trial? The answer is, no, you can't. You can't go up on your own and speak to the judge. You have an attorney to do that for you. If you were to go up and speak to the judge privately, we call that an ex parte discussion. Now, what does that mean? It means that one side is now having a conversation with the judge who's involved in overseeing this trial. An ex parte discussion is one-sided conversation. Now, why is that a big deal? It's a big deal because if the defense attorney is sitting in the courtroom and now he sees you walk up to the judge to have a conversation and engages you, and the judge engages you in conversation, how does the defense lawyer know what it is that you and the judge are talking about? How does he know, how does the defense lawyer know that you're not trying to collude or to say something embarrassing or who knows what? Or to argue? You don't know. The reality is that the person who is observing from a distance has no clue what it is that you're talking about. And in reality, your attorney is the one who's supposed to be speaking for you. It is your attorney who will be the one to talk to the judge. So in that instance, can your lawyer go up and ask the judge privately why he ruled a certain way? The answer is no, he can't. There are no ex parte communications that are supposed to occur during the course of a trial. You want to know why? Again, it's because each side would not know what the other is talking about. If one of the attorneys wanted to talk to the judge about a particular issue, then the other side has to be there listening and participating in that conversation. In that instance, it's perfectly okay. And I will tell you, there is one instance, one clear instance where each side gets to talk to the judge separately that is appropriate. You want to know when that occurs? It occurs during settlement discussions. If both sides are willing and eager to try and settle the case, whether during trial or before trial. Now they approach the judge and say, Judge, we'd like you to help us try and negotiate this case. In that instance, the judge will want to speak to each attorney separately. The judge will want to get information from each attorney about how they feel about the case, where they think the case is going, how much money they may have or are willing to accept. And it's important to be done privately, because now the judge will have a better understanding of where each side stands and their position. Now, at some point, the judge will call both sides in and try and negotiate or continue the negotiation separately. So in those instances, it is perfectly acceptable during the course of settlement discussions for the judge to speak to each attorney separately. But during the course of trial, it is not appropriate for the attorney to talk to the judge privately. It is not appropriate for you as the injured patient bringing a lawsuit to go ahead and speak to the judge privately. Nor would it be appropriate for the doctor, the person you have sued, to go ahead and speak to the judge privately. So why do I share this great information with you? You know, I share it with you just to give you an inside look at what goes on during a medical malpractice trial here in New York. You know, I understand you're watching this because you likely have questions or concerns about your matter that happened here in New York. Well, if you're contemplating bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8688. 8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.